Want to do the roll call? Also, let me announce, there's no gun bills in this committee. If anybody's waiting around. All right. We've got bills to be re-referred. Okay. We've got, there's several bills. What I want to do is put them in a block, and I'll explain. There's 1, 2, 3, 4, 5, 6, 7, and I'll take one out of the block. 6 of them are identical to Senate bills, and the Senate bills all passed 14 or 15 to nothing here and 40 to nothing on the floor. So, and they're identical. So that would be Senate Bill 49. That would be, the House bill, excuse me, 336, Delegate Price, 438, that's, no, it's not 438, excuse me. 835, that's Delegate Sullivan. 840, Delegate Murphy. 1244, that's Delegate Heretic. And I should have told you, Price's bill is similar to Lionel Spruill's Senate Bill 49. Sullivan's Bill 835 is similar to Senator Lewis's 831. Murphy's Bill 840, similar to McDougal's 605, identical. And Delegate Heretic, his is identical to Senate Bill 1244, Senator Morrissey. House Bill 1273, Delegate O'Quinn. Her bill is similar to Senate Bill 846, Delegate Pillion. And House Bill 1376, Delegate Austin, is similar to Senate Bill 953, Senator Edwards. There was another one, but I'm going to take that. I'm not going to put that in the block because there's some questions about it. So I need a motion to.
Mr. Chairman, we have one Delegate Price bill
I have that.
337.
3.
Okay, thank you.
Okay, so I need a motion for House Bill 336, 835, 840, 1244, 1273, and 1376. All right, is there a second?
Second.
Okay. All right. I'll repeat it. You want me to repeat it? You got it?
So, and it's my mistake, I don't have it marked on your sheet, 835.
I
Can
had.
you pull that out?
I thought you wanted Forestville utility
one out.
easements.
Pull this one out.
835?
Yeah.
All right, 835, which was similar to Senate Bill 831. That's House Bill 835 is Delegate Sullivan's. 831 was Lewis. So that's out of the block. All right. All those in favor of voting the remaining bills in a block, please vote aye. Those opposed, nay.
It's because this needs to go finance along with that 438 and 835.
All right.
Identical and you
I-
not
I-
unanimous, so.
Is Delegate Foy here? Delegate Heretic? Is he here? All right.
Explain it, it's similar and then we'll go into some of the finance, or it's identical.
Here's Delegate Heretic's bill, is workers' compensation. Dealing with the post-traumatic stress disorder for law enforcement officers and firefighters. That is similar to, or identical, excuse me, to Senate Bill 561, Senator Vogel's bill, which passed this committee 12-3 and the full Senate 37-2. The motion would be to report and refer to finance. It's been moved and seconded that House Bill 438 be reported and referred to Senate Finance. Okay. All in favor? Excuse me. Sorry. That's done.
13, noes, 1.
All right, we have another that needs to go. That was in the block that I pulled out. House Bill 835. That's Delegate Sullivan's bill. That's water utility and sewer utility asset acquisitions, fair market value valuations. That was identical to Senate Bill 831 of Senator Lewis. The vote here in our committee was 12-0. The vote on the floor was 40-0. So I need, the motion would be to report and refer to Finance Committee. It's been moved and seconded that 835 be reported and referred to Finance. All those in favor, vote aye. Those opposed, no. Okay.
Ayes 14, no 0.
All right. Now, we have House Bill 576. That's Delegate Keem's bill. Is he here? All right, Delegate Keem's bill, HB 576, is identical to the bill I had, 782, which passed here 14-1, and the floor 32-7. And it was the bill dealing with that burial of that transmission line at Tyson's Corner, of which met all the criteria of the Senate Bill 866 in 2018 that Senator Wagner and I had. So I would need a motion for that.
So move.
All right, moved and seconded that House Bill 576 be reported. All those in favor, vote aye. Those opposed, no.
Ayes 14, no 0.
Okay. We didn't do Ward's,
Chairman Ward's bill, 813.
okay. Delegate Ward? Delegate? Okay. So we got, is Delegate Delaney here? Did you all get notified that you were going to? You did. You were the only one, huh?
God bless you.
All right, Delegate Tran, you're up. And you have House Bill 1199, employee misclassification, retaliatory actions prohibited, civil penalties. And it's identical to Senate Bill 662. That was Senator Boysko's. That passed this committee 12-3 and 25-13 in the House. Go ahead.
Thank you so much, Mr. Chair and members of the committee. House Bill 1199, as the chairman said, is identical to this bill that was carried by Senator Boysko. It provides whistleblower protections so that an employer cannot discharge, discipline, threaten, discriminate against, or penalize an employee or independent contractor because the employee or independent contractor reported or plans to report worker misclassification. It's a bill that is an administration bill, and Jane from the Chief Workforce Development Advisor is here to answer any questions. But according to Jay Lark, considerable harm is being done when properly classifying, due to properly classifying employers, if they are being misclassified, workers are losing wages and benefits, as well as we are losing out on Virginia taxes and revenue. So this is just to make sure that we are supporting those who are able to come forward to report instances or plan to report instances of worker misclassification.
Second.
All right, it's been moved and seconded that House Bill 1199, employee misclassification, be reported. All those in favor, vote aye. All right, opposed, no.
Ayes 12, noes 2.
Okay,
Joanne Waters, Mr. Chairman.
yeah, Delegate Ward,
Thank you.
you have 813, and, yeah, well, you've got on House Bill 813, credit unions, Board of Directors compensation. That's, I don't know why we didn't have that in the block. I thought we had it in the block, but I guess we didn't. Senate Bill 296, which was Marsden's. Marsden's passed this committee 15-0, and the floor 40-0. And her bill is identical. Do I have a motion? All right, it's been moved and seconded that House Bill 813 be reported. All those in favor, vote aye. Opposed, no.
Ayes 14, no 0.
Okay. You have other bills here? Or do you have 395? Yeah. The minimum wage bill that you have is a little bit different than what left the Senate.
Yes.
And in the current form that it's in, yours wouldn't leave the Senate. So we'll give you something to get to conference, okay?
Okay.
All right. What hers does is the way my bill started out. Starting in July, $10 an hour, and then up, let me know if I'm wrong, and then every year, July, up $1 till it reaches $15 an hour.
That's about right.
That would be 2025.
Yes.
Yeah. So, what we might want to do for now is conform her bill to mine in the way of a substitute. Mine is 7, plus it's got other, side things in it. Right. So, is there a motion to conform? Second. Is there a second? All right. It's been moved and seconded to conform Delegate Ward's bill to my bill, which is Senate Bill 7. All those in favor say aye. Aye. Okay, now need a motion on the bill.
Mr. Chairman, just a question.
Sure.
Mr. Chairman, when we were on the floor, things were moving quickly. We had a substitute. We apparently did not put on the study language, and honestly, I don't know if it was on purpose or not on purpose. But I'm wondering if we're going to go to conference, if we couldn't have a vehicle that had the study language in it so it can be part of the conference.
Well, let's do it on the floor.
Okay, that's fine.
After we take a look at, I'd have to go back and take a look at Sorrell's.
Sure.
amendment.
That's fine.
Okay, so, all right, is there a motion? We've conformed 395 to Senate Bill 7. Is there a motion to report? Second? And it has on here a request to go to finance, but they've already put the money in the budget for mine, so the money
And mine
is.
as well.
And yours as well?
Yes.
So I don't think we really need to send it to finance. So the motion would be simply to report. Do I hear a motion?
Move the report.
Second.
A motion and a second to report House Bill 395. All those in favor vote aye. Opposed, nay.
Ayes 12, noes 2.
Okay,
One more bill,
which one is that?
1503.
Hold on here.
It's the last one on
Yeah, that's the similars, okay. 1503 is health insurance coverage for the autism spectrum. And it's similar, it's not identical. If you want to go ahead and briefly explain your bill. By the
Yes.
way, it's similar to Barker's bill, which passed here 15-0 and 40-0 on the floor. But go ahead and briefly explain your bill.
Okay.
Mr. Chairman, if you want to expedite things, I think we could just conform both of our
Okay.
bills and work it out,
Right.
rather than
All right.
having to do it here, so.
Okay? That'll get it moving, we'll get it worked out.
All right, Mr. Chair.
Sure.
There are a lot of people here from Autism Speak, and they don't have to come up and speak, but if you would just let them stand and be
Sure.
recognized that you
Those
know they're here.
From Autism Speak, that
We recognize, we
we're
recognize.
here, please stand up. Okay.
Thank you so much,
Now,
Mr.
and
Chair.
thank you all. All right, we're gonna need, we're gonna have to vote to conform hers to mine, Dr.
mine,
Barker's.
yeah.
All right, it's been moved and then
Second.
seconded, that we conform the two. All those in favor, vote aye. All right, opposed, okay. Bills before us. In a form of a substitute. Okay, that's, the motion is to report substitute for 1503. Is there a second?
Second.
All right, all those in favor vote aye, those opposed, no.
Ayes 15-0.
Thank you, Mr. Chair,
Yours is
members of the
pretty- it's pretty
committee.
close to his,
All right, thank you.
okay. All right. Let's see. We've done that. On 984. Yeah, but it was 12-3. Okay, we can do that. All right, Delegate Delaney, she's not here. All right, here you go. Delegate Delaney, come on up. Your misclassification worker is identical to mine,
Yes, Mr. Chairman.
okay? The reason that I took this out of the block was the vote in our committee on my 894 was 12-3, but on the floor it was 21-19. Go ahead and briefly just explain, just very briefly,
Thank you, Mr. Chairman.
because we had one somewhat similar with Tran. Delegate Tran had one.
Yes, and so, Mr. Chairman, this is the administration's recommendations from their work group, their interagency task force that developed some policy positions for worker misclassification that we could address. So, for over a decade, the General Assembly has considered the harm of misclassification of employees in Virginia. Of course, you all are very familiar. It's a process which creates a competitive disadvantage for Virginia businesses who follow the law, deprives the Commonwealth of millions of dollars of tax revenue. And so the bill before you, it helps to address this issue by allowing workers who are misclassified by their employers, who have been found to have been misclassified willfully by their employers, that they bring forth civil action for the individual damages in the amount of any wages, salary, employment benefits.
Okay. All right, you all have heard it, and you've heard it before. Need a motion to report. All right, it's been moved and seconded that House Bill 984 be reported. All those in favor vote aye, those opposed nay. All right.
Ayes 12, noes 3.
Ayes 12, nays 3, the bill's reported.
Thank you, Mr. Chairman. I do have two other bills with you in this committee. Were you intending to hear those
Okay.
now?
Oh, you're here.
Well,
All
I'm
right, you have
here.
800, you have 800 and 807?
Yes,
Now,
800
this
and
is in the
807.
category of similar bills. You want to take up 800 first?
Sure.
Okay, 800 is similar to Marsden's bill, which passed here. No, it was continued, 14-1. Carried over.
So,
continued.
Mr. Chairman, I can explain the difference. We certainly heard some of the concerns that were addressed in this committee with Senator Marsden's bill, and we did have a few more weeks to work on this issue before we brought my version of a similar concept over. We are trying to address the issue of wage theft with this piece of legislation, and we really wanted to try to specifically target those most vulnerable workers who are often considered, day laborers. These are the individuals who are often picked up by a contractor for either a day's work or maybe a project's worth of work, and several days' worth of work, and really don't know anything about who's hiring them. And they then will sometimes become victims of wage theft. And this is when the employer either writes a bad check or simply fails to pay them. Right now, when those individuals go to small claims court, they're often asked to prove who the employer was and an address where the court would be able to find them. And without that information, that burden is really put on that very vulnerable worker. I had a story of a gentleman who lives in my district who'd been hired to do some painting work over several days, was owed a little over $1,000 and was
So
never
this
paid.
bill is applying essentially only to day workers?
So we have added to some of the original language, the substitute language that got out of the House, as you can see, adds quite a number of exemptions that really got at some of the concerns that we heard the Senate had, so that we don't want, the Boy Scout who's coming to put mulch down for their fundraiser would need to have this data provided. This would have exemptions for students, internships, folks in jail, work study, folks under the age of 18, babysitters, those who are employed with church or charity work, as well as those who are paid through state funds, such as the home workers. We did have some feedback that there were some who were hoping that we could offer an amendment for the first exemption for anyone employed in domestic service. So we did have prepared an amendment to strike in line 14 in domestic service in or about a home, just knowing that some folks who are in this vulnerable category sometimes do work in homes. But, the spirit of this bill was to address the wage theft issue of those day laborers who are being picked up with no information about who their employer is, to require that those employers provide some basic information about who they are, an address and general terms of the employment, so that if they do need to go to court, they'll have that basic information to offer the judge.
If let's say if Home Depot hires a cashier, they got to give them a detailed report?
They would not, Mr. Chairman. Currently, we modeled these exemptions after the pay stub bill that was passed out of the body last year.
Right.
So those folks would already be considered employees, and that would not pertain to them. This would specifically pertain to those individuals who are not required through the current pay stub requirements that we passed last year. This would only pertain to those workers who are most vulnerable and really getting nothing from their employer.
So when essentially you're being paid by a professional payroll company, that pretty much covers it.
Yes, Mr. Chairman, because of the legislation we passed last year, those folks are already required to get pay stub information where they have, if they have a claim against their employer for not paying them, they've got the data they need to go to court with.
Senator Marsden.
Thank you, Mr. Chairman. Two things. One, the Centerville Immigration Center, which I think you're familiar with, out in Centerville, Virginia, which operates to help these individuals connect up with potential employers. I think the figure that was given to me by a representative of the center was that last year there were $290,000 in employees not being paid, who people came to pick up. So it is a serious problem. And actually, what I'm hoping this bill will do, and I'd also move to report this bill at the appropriate time, is to get employees, the potential employees, used to asking for this information, because a lot of times a homeowner won't know they need to provide it, and there's no penalties in there for not, but that they will ask for this information, that they'll have a form ready that they've created themselves to make sure that they've got that information so that they can pursue the payment for the work they do, because some people come out with the very expressed intent of cheating people. Okay. They do it on purpose. It's not an accident, and it's a huge problem. And I think this bill goes a long way towards addressing the issue.
We need to adopt her amendment. You want to quickly go over what the,
Yes, Mr. Chairman. So in addition to the legislation that's coming over from the House, after some further feedback, we did have a proposed line amendment for you to consider, which would be to strike on line 14, in domestic service or in and about a private home. And Mr. Chairman, the purpose of that amendment would just be to realize that, some of these daily workers or folks that are employed in these vulnerable conditions may be also doing domestic service in a home in addition to the contracting work. And that would be the will of the committee as to whether or not you'd like to adopt that amendment.
I think it helps the bill. Move the amendment. All right, the amendment's been moved. Is there a second? All right, all those in favor of adopting the amendment, which on line 14 removes the language, any person employed in domestic service or in and about a private home. Did I phrase it right? Okay, all those in favor, say aye. Aye. Opposed? All right, the amendment is adopted.
Mr.
All right.
Chairman,
Move to report.
There's been a
As
motion.
amended.
Hold on, hold the motion. Yeah.
So, and as I read this, and I
Senator
apologize, my attention was a little bit divided, but so if I've got a guy who comes to cut my grass once every 2 weeks, this means I've got to give him that disclosure.
So, Mr. Chairman, my understanding is that that would not be the case because we have we have some amounts of time that the individual would have to work, and so we really tried to capture it to be, let me see if I can find where the language is in
I
here.
have a big lawn.
Right. And that was what we wanted to try to make sure that we were not capturing, if they're with a company and you're hiring somebody with the company, or hiring a teenager or something like that, that you would not need to give them that basic information.
Well, Mr. Chairman, I do see Section A, which says somebody 18 years or older. So if it's a 16-year-old, I don't have to do it. But if it's a 19-year-old, it would be, they would be employed for a project for a total of 10 days or less, right? Because they're just cutting my grass on a periodic basis. I don't see that they would be excluded. Paragraph 1 relates to any person employed in or about a home, which I think cutting my grass would be. So it looks to me like they'd be covered by this.
So, Mr. Chairman, I think with the amendment, and that was where, we were trying to get to with the amendment, we wanted to try to also capture domestic services that are sometimes provided in a home.
Private home.
So I think if we do adopt the line amendment within or about a private home, if you're hiring an individual to cut your grass or provide domestic service, it would be in fact covered by the bill, and you would need to let them know the rate of pay and your name. They know where you live because they're there. And so that's where that line amendment is up to the pleasure of the committee. We propose it.
So, but you want to require me to have to give that notice?
I would say, Mr. Chairman, I would say to the senator, yes, in the sake that there are individuals who are being hired and then not being paid. And
Mr. Chairman, how about the guy who knocks on my door after the snow falls saying, not a child, somebody 18 years, 19 years old, says, can I shovel your driveway? I'd have to go to my computer, get his information and print that out for him, or else I'm in violation, right?
With the amendment takes care of your problem.
I thought she said
It
she
exempts
wanted that
out
covered.
anybody who is in or about a private home. Look on line 14. It removes them.
so Mr. Chairman, if you want to keep that in, I think,
Required.
Mr. Chairman, what I would say is that the IRS code is what would need to be dictated.
No, we shouldn't adopt your amendment.
Okay, and that's,
Oh, yeah.
that
Having
is,
voted on the prevailing side by which we adopted that amendment, I move to reconsider. But you have to hit the button here. Motion to reconsider. Okay. All right, so the amendment's before us, and I would move that it be rejected.
Second.
It's been All right, all those in favor of rejecting the proposed amendment, say aye. I mean, you do understand the problem it creates.
I do understand, Mr.
Although
Chairman.
we're taking them out.
And I think that it does, and my apologies for the confusion, because I do think that IRS rules would determine that some of those individuals are independent contractors by the nature that they're bringing their own tools. They're, if they're coming to your home and they're knocking your door and selling their services under IRS, they would be independent contractors anyway, and this would not apply. I would think that would be accurate, but I think to avoid the confusion, we'll keep it, I'm happy to keep it intact as it is, and we can explore it further.
Mr. Chairman, no questions, but it just seems to me that we sent Senator Marston's bill to be looked at for some pretty good reasons. One we just had. The other is, it appears that on line 31 that if you have a babysitter that's 18 years of age and they spend the night and they stay there more than 10 hours, you got to write up a report. And if you change their wage, you got to report how much the wage is changing and determine all the items on lines 34 through 44. And that's just an example, Mr. Chairman. It just seems like we sent Senator Marston's bill to be looked at so it could fix problems like the ones that we're talking about right now.
And Mr. Chairman, I would say, we deliberated a lot about these concerns, wanting to try to specify, the issue that is with these daily workers that are being exploited. And so the exemptions that we put in, we attempt to address that. So that we are trying to, carve it out so that we're really targeting the folks that are being picked up for work, for work sites and are often not being paid in some of the cases that you've heard.
Mr. Chairman,
Senator Bell.
unless I'm missing it, does it say on the part in section B what date this agreement takes place on? Because I see where we're saying the pay date, but I don't see it says the date that this agreement takes place.
Mr. Chairman, I would ask the senator the date that they're signing the document. Is that, or that the document's being provided? Is that the question?
Well, Mr. Chairman, and maybe some of the attorneys here, when I hire people, I sign the agreement, I date it that day, and I have people sign it accepting the agreement. And frankly, so that makes kind of a contract. What I see here, I'm not seeing where we've got it in that kind of a form. It sounds like that's what we're trying to do to keep them from getting cheated, is making a contract. But are they both signing this? Because I'm not kind of interpreting that way.
No, Mr. Chairman, if I could maybe clarify a couple of points.
I think council also wanted to say something too.
Mr. Chairman, Senator Bell, I was just pointing you to line 32. It says every employer shall furnish to each employee at the time of the employee's hiring a written disclosure, but no, sir, there is no requirement that anyone sign it.
So, Mr. Chairman, I would make one point that it's not a contract. It's simply providing information so that if someone is a victim of wage theft, they have the information available. I'd also, I think, want to make the second point that some of these, this is an example of the babysitter under IRS code. Those situations would already be someone that, I know not a lot of people do it, but that they would already have to be, considered an employee. So what we tried to do with the exemptions was to carve out those who are not an employee. If you have a babysitter working in your home, and when you look at the math for how much that is in the, for the IRS code, they may already need to be considered a W-2 employee. Not a lot of families necessarily follow that law, but it certainly is the law. And so I think what we attempted to do here was to specifically carve out things that would not already be part of the IRS code.
Mr. Chairman.
All right, Senator Newman.
Mr. Chairman, I think the delegate has worked on this, and Senator Marston helped us with it. To me, there's just too many things we don't know, and I think before we pass this, we should get it right, and I think we can if we hold it over for the year. It's not to kill the bill, it's just to hold it over and get it right. I would move that we carry the bill over to the 2021 session.
There's a motion and second. All those in favor of carrying it over for the year, vote aye.
Ayes 14, noes 1.
All right, the bill is carried over. You have another one.
I do have one more.
That's
Seven-
807.
807. And Mr. Chairman, this bill is
That's,
very similar to Senate Bill 766.
Okay, Senator Barker's bill passed this committee 15-0 and 40-0 on the floor.
And Mr. Chairman, I would be happy to amend my bill to Senate Bill 766. There was one point on that I did want to make and have that be of course, the pleasure of the committee. But I am happy to amend the bill. I think it fixed some of the concerns that were with my version. However, on Senate Bill 766, language on line 17C, the commission may issue regulations to establish. There were some concerns that with that permissiveness as to whether or not that would still be optional. This was the bill, senators and Mr. Chairman, that deals with the explanation of benefits that pertain to sensitive health information. This is when victims of sexual assault or domestic violence are going to the hospital, and then their potential abuser would then receive the explanation of benefits in the mail.
What we're going to do is we're going to conform your bill to Senator Barker's.
So moved.
Okay. All right, it's been moved and seconded that we conform her bill to Senator Barker's. All those in favor, say aye.
Aye.
Opposed? All right, the bill is before us. Yes, this has to, the motion would be report, and hold on one second. Senator Barker, was the money there in our budget? This has to go to finance.
Actually, I think the reason for the money is no longer in the bill in 766 or this as with that amendment. So I don't, I mean, we can still send it up to finance, but I don't think there's
a budget impact.
No, there's no longer any budget
No,
impact.
that's what you're saying.
Right.
Yeah. Okay, well, we'll make the people on the 14th floor happy. So the motion would be to report and refer. Yeah, Senator Spruill.
Why we keep sending bills to finance when there's no finance report? We just keep
I'll tell you what.
all committees keep doing that.
We'll move this directly to the floor, and I'll tell Janet you put a gun to my
Please
head.
do, please do.
Okay. All right, the motion would then be to report as amended, 807. Is there a second?
Second.
All right, all those in favor of reporting 807, vote aye, as amended. You're done.
Ayes 15, no 0.
Thank you, Mr. Chairman. Thank you,
Okay.
members of the committee.
All right. Okay, let me go back to. Yeah, I know, but hold on.
Mr. Chairman, I believe we have a, Senator Bagley, aren't you have a committee hearing? Aren't you chairman of the committee coming up?
Yeah, yes, sir.
Mr. Chairman, we have a chairman of the committee that's been meeting, so we want
All right.
to get him out. Bagley.
I know that. That's good. Delegate Bagby, then you have 789.
Thank you, Mr. Chair, members of the committee. I could sit here all day. This is my kind of meeting and my kind of people. This bill that's before you today is very similar to in posture of some of the bills you've taken up to date. Is a bill you've seen before.
Is that your is that 789?
789 is
Right.
similar to Senator Locke's bill, and
Right. That passed here 11-4 and 2316 on the floor.
correct, Mr.
Okay.
Chairman.
Go ahead and briefly explain.
And so the legislation is the comprehensive lending bill. I know you all had a full and fair hearing on this legislation, not only here, but also on the floor, as we had on the other side of the hall. And so we can have a full and fair hearing if you want. There's a number of individuals here to speak today. And so if you want them to speak, I think they will be excited to do so.
Is there anybody
But I also came here fully prepared to fight the enactment clause that you all put on Mamie Locke's bill, but if you all wish to conform, I will sit here quietly because Sproul told me to do so.
All right. And Locke's bill, as I said, passed here 11-4 and 23-16 on the floor. Is there a motion to conform it?
Move to conform.
All right, is there a second?
What are we voting on?
I need a second.
Second.
All right, all those in favor of conforming his bill, Delegate Bagby's to Senator Locke's 421, say aye. Aye. All right, the bill is before us. You all know, because all right.
Move the bill be reported and refer to finance.
It'll come out. So, all right, you've heard a motion and second to report and refer to finance. All those in favor of reporting and referring to finance, vote aye.
Ayes 11, noes 4.
Thank you, sir,
Okay.
Mr. Chair, members of the committee.
All right, Delegate, we're going down this. Huh? You want to take it? All right, Delegate Ware, you're up.
Thank you, Mr. Chairman. And this bill did not have a Senate companion. It is House Bill 143, and it would simply repeal the sunset provision on military trailing spouse being eligible for unemployment compensation. You'll recall that when we adopted this some years ago, we wanted to look at it, see what the cost would be to the fund, and we found that it's on the order of $600,000 annually, but doesn't affect the cost to the typical business person. And so this bill would simply repeal the sunset provision.
Okay. You all heard the bill. Second. All right, motion and second to report House Bill 143. All those in favor, vote aye. Opposed? All right.
Thank you,
Ayes
Mr. Chairman.
15, no
Members.
0.
Thank you.
All right, next is Delegate Krizak.
Thank you, Mr. Chairman, committee.
What's your bill?
This bill is HB 333. It eliminates the exclusion in the Virginia Minimum Wage Act for the persons whose earning capacity is impaired by physical deficiency, mental illness, or intellectual disability. And that's what it says now. So what we're doing is we're getting rid of that. These are people of differing abilities who are able to receive fair and equal pay to become self-sufficient. It's time to take that language out of the code. It's similar to your bill, Mr. Chairman. And it's supported by the ARC, Virginia Access, all of the different groups out there that are in this.
How is your bill different from Senator McClellan's 719?
I only know, I have a chart that compares yours and Delegate Ward's and mine. I don't know about Senator McClellan, so I'm sorry.
That's all right. Mr. Chairman, I know the delegate as well, meaning on the floor, we had this debate, and I know that about the delegate's compassion, but the fact is that we need to love people that can't take care of themselves, and we talked about this, and the fact is that these are individuals that desperately need a pathway to work, and this is going to take that away from them.
No.
Mr. Chairman, I would hope that we would once again not pass this bill and carry the bill over to next year.
Mr. Chairman, can I respond to Senator Newman?
Sure.
This shouldn't do that. This is the language that you're concerned about is not in has been amended. My bill has been amended over the process through the House side. It doesn't have the 14C of the Fair Labor Standards Act language that's still in there. So it still allows for what you're. It still provides that.
Mr. Chairman, I just don't think it does, and we had this discussion on the floor. It still strikes number 12. Is that correct? Did you make an
Yes,
amendment?
that's correct.
Mr. Chairman, that we've discussed with council. What that says is any person's earning capacity is impaired by physical deficiency, mental illness, or intellectual disability. Mr. Chairman, that's exactly the discussion that we had on the floor, and I would hope that we would be consistent with this bill as we have been with the other bills.
I didn't have a bill that dealt with that. It was McClellan's bill.
Oh, it's McClellan's? Okay, well, you're right. On the floor, you guys brought that back in. It was off that. And the other part of the McClellan's bill that is liked is is line 11, where it says any person whose employment is covered by the Fair Labor Standards Act. So the language in McClellan's bill that's really good is any person who is paid pursuant to 29 U.S.C. Section 214C of the Fair Labor Standards Act of 1938 as amended. That's language that that folks in this sector would like to see happen. Maybe we can get it. Is there a bill in the Senate that's moving through that we could maybe bring it to conference?
The one that we had that was so much similar to yours was Senator McClellan and continued education.
Okay, I hear you.
Motion and second. Carry the bill over. All those in favor of carrying the bill over, say aye.
All right, thank you very much.
Ayes 14, no zero, one abstention.
All right, Delegate Hodges.
Thank you, Mr. Chairman. Have two bills today, House Bill 1266, which deals with septic, Mr. Chairman, members of the committee. Actually, I have two.
1266.
Great. Thank you, Mr. Chairman.
Motion, I need a second. All those in favor of referring it, vote aye.
Thank you, Mr. Chairman. You also have before you House Bill 1290, which is identical to Senate Bill 251, Senator Edwards. It's a- Yes, sir.
Mr. Chairman, Delegate Hodges, they're nearly identical. Senator Edwards' bill needs a technical amendment that I did not catch when it was coming through the Senate. So
Okay.
they're substantively identical.
Okay. So we'll need to make a technical amendment on the House side? Okay.
Okay. All right, will the technical amendment?
You don't need to make it.
You don't need to do it.
Move to report.
All right, the motion and second, the report, House Bill 1290, Hodges bill, dealing with pharmacy benefits management, licensure and regulation. Edwards bill passes committee 960, 32-7 on the floor. All right, do I got a motion? Is there a second? Second. All right, motion second, the report 1290. All those in favor, vote aye. Report.
Ayes 12, noes 3.
All right. Thank you, Mr. Chairman.
Delegate Kilgore.
Mr. Chairman, thank you. I have three small bills. The first bill is House Bill 154. It deals with reinsurance credits, and basically what that is insurance for insurance companies. And basically what this does now is it allows the bill would make changes to the Virginia Code's article on reinsurance to comply with the new federal requirements, and that's basically what the bill does. There was usually this reinsurance is left up to the feds, but we have to do certain actions to keep up with the federal requirements, and this was brought by the Bureau of Insurance.
Doesn't go away with their capital requirement.
No, no. No, they still have to maintain a minimum solvency and capital ratio and provide notices to the State Corporation Commission in events of noncompliance of any of the requirements. So it keeps all those jurisdictional issues.
Any questions of the paper? All right, is there anyone here who feels compelled to speak in favor of the bill? Anyone with a different opinion? All right, bill's before us.
No report.
All right, there's a motion and a second to report House Bill 1254. All those in favor, vote aye. Opposed, nay.
Ayes 15, no zero.
Thank you, Mr. Chairman. Next bill I have is House Bill 1339, and that's crowd funding. And basically, this is the bill that was introduced by Senator Edwards in 2017, Senate Bill 763, and that expires,
1339.
Yeah, 1339. And this Senator Edwards had a bill that was introduced and we passed in 2017 that expires 2020 unless we reauthorizes it. And what we would reauthorize, and basically what this bill does is removes a sunset clause. It allows subordinated debt to qualify for crowdfunding with compliance to existing SEC rules, and it adopts a rule that was recommended by the State Corporation Commission staff in their report to legislators in 2018 and 19 to make it easier to use the internet for crowdfunding for Virginia issuers. So you had a Senate Bill 542, I think.
Senator Edwards, and that bill on the line committee members, which this is similar to, passed committee 15 to nothing, and the House had the Senate 440.
I move to report.
All right, so motion to report.
Yeah, it's on the phone. Yeah.
All right.
What's the difference?
Yeah, that's fine. That's fine.
All right.
You want to put that in there?
Motion.
This is mine.
I need a second. Second.
Yeah.
Delegate Kilgore's bill, Senator Edwards' bill 542. All those in favor of conforming it, vote aye.
Aye.
Say aye.
Aye.
All right, and the amended version is now before us. All right, there's a motion to report. Is there anybody in the audience? All right, there's a motion and a second.
Any crowdfunders?
To report 542. All those in favor, vote aye. Excuse me, House Bill 1339.
Ayes 15, no zero.
That bill's reported.
And my last one, Mr. Chairman, is House Bill 1558. And this bill, Mr. Chairman, sets up an ombudsman at the Virginia Workers' Compensation Commission. We have a high percentage of injured workers, 40%, who attempt to navigate workers' comp system without attorneys. And while we have a call center at the commission, it only gives limited information. And this ombudsman is set up with money from the Workers' Compensation Commission, and it also is set up as a result of JLARC, who recognized the need for this program in workers' compensation.
All right, the motion on this would be to report and refer to finance.
That's right.
All right. Got a motion and a second to report House Bill 1558 and refer to finance. All those in favor, vote aye. Opposed, nay.
Thank you, Mr. Chairman.
Okay.
Ayes 15, no zero.
All right. Delegate Bulova.
Mr. Chairman, he had stepped out.
He's gone. All right. Next on the sheet, the sign-up list is Delegate Wilt.
Thank you, Mr. Chairman, committee members. Before you is House Bill 1240. Basically, it just cleans up the code in reference to legal services plans. Last year, carried legislation to pull that out of the insurance, but that kind of got sideways with some folks. So they've spent the last year coming up with some code cleanup, leaving it where it's at, but just making it a little bit easier for these programs to move forward.
Which programs?
The legal services plans.
Okay. Yeah. Okay.
Mr. Chairman, can I just maybe?
Senator Obenshain.
Tony, my understanding is that, I mean, this is basically covering 5 companies that offer this kind of coverage in Virginia?
Mr. Chairman, that's correct.
And the bill maintains all the consumer protection that's provided in the current statute?
Yes, that's correct. Mr. Chairman, I would also add, out of those 5, it's like 2 of them do about over 90% of the work.
And this just modernizes and streamlines the regulatory framework that already exists?
That's correct, Mr. Chairman. I can address a couple. It allows legal services organizations to register sales representatives with VDACs, allows legal service organizations licensed in other states.
Mr. Chairman, unless there's anybody in opposition, I'd move to report.
I second.
All right, is there anyone speaking in favor or against the bill? All right, questions by committee?
Move to
Other than
report.
Senator
Second.
Obenshain? All right, it's a motion to report and a second. House Bill 1240, all those in favor, vote aye. All opposed, nay. All right, 1240 is reported.
Thank you, Mr. Chairman, committee members.
Okay, Delegate von Valkenburg.
Thank you, Mr. Chairman, members of the committee. House Bill 330 is very close to Senate Bill 480, carried by Senator DeStef, that passed out of here. It's there's 2 small changes, or there's 2 small differences. The House bill has an exemption, one exemption built in for low-wage employees, and the Senate version has an amendment that Senator Peterson put on for a course of action in the courts. But otherwise, this is a bill to ban non-compete clauses for low-wage workers.
All right. All right, so is there a move to conform this to Senator DeStef's? All right, it's been moved and seconded to conform this to Senator DeStef's. It's a problem, you work it out.
Yeah.
You know, in committee.
Yep.
All right, all those in favor of conforming it, say aye.
Aye.
All right, bills before us.
Second.
All right, it's been a motion and a second to report House Bill 330 as amended. All those in favor, vote aye. Opposed? All right. Done.
Ayes 14, noes 1.
All right, thank you, Mr. Chairman.
Okay. Delegate Aird. Delegate Aird here? She's not. Delegate Rasool, you're up.
Thank you, Mr. Chair. Before you is House Bill 1037. House Bill 1037 is similar to Senator Hashmi's Senate Bill 404 with relation to short-term limited duration plans. The differences, there are a few. The major difference that I think you all had discussed as far as amendments were concerned between 404 and 1037 with regards to the short-term limited duration plans was that my bill allows for one renewal within a 12-month period, but it's a non-consecutive renewal. 404 allows for a consecutive renewal as it moves forward. And then there were a couple of other smaller differences as well, as I can tell, Mr. Chair.
Mr. Chair, I would move that we conform to Senator Hashmi's bill.
All right, there's been a motion, second, that we conform House Bill 1037 to Senate Bill 404. And there's a second. All right, all those in favor of conforming House Bill 1037 to Senate Bill 404, say aye. Aye. Opposed? All right. Bills before us. The vote in committee was 8-7, and on the floor it was 20-20.
Move the report.
Second.
There's a motion and a second to report House Bill 1037 as amended. All those in favor vote aye. Those opposed, nay.
Okay.
Ayes 12, noes 3.
All right.
Thank you, Mr. Chairman, members of the committee.
All right. Next on the hit parade is Delegate Carol Foy. Delegate Foy, you have several bills. One of them we took out of the block, and I made a note on here, buy for the day. But that was, I'll tell you what it was. That was 831, utility easements, location of broadband and other communications facility. It was identical to Senate Bill 794, Senator Lewis's bill.
Yes, Mr. Chairman.
Somebody, came to me and said they've discovered some problems, and they brought it to your attention. Are you aware of this?
Yes, Mr. Chairman. I believe we have peace in the valley because I have an amendment,
Okay.
a line amendment
They
that I
said
believe
they
will.
thought you would.
Yes, yes, Mr. Chairman.
All right, hold on. Let me turn to the bill.
I'm sorry?
831, everybody.
Yes, substitute, yes. And then a line amendment. Oh, substitute. Okay.
All right. How does the substitute differ from the original bill?
Yes, Mr. Chairman and members of the committee.
Oh, we need a motion to adopt the substitute.
So moved.
All right, it's been moved and second to adopt the substitute. All those in favor say aye. Aye. All right, substitute's before us.
Okay.
Transmit.
Yes, Mr. Chairman. Now that the substitute has been voted on, now I have a line amendment. My substitute was to conform my bill to Senator Lewis's broadband bill, which I believe passed unanimous out of here.
Yes.
And so the line amendment is what the agreement came to the group that had objected to our bill. And the line amendment begins on line 153.
That's on the substitute.
Yes, yes, sir.
Line 153.
Yes, sir.
All right.
And it strikes beginning the word solely by virtue of the provisions of this section. And insert absent an agreement to the contrary. And Mr. Chairman, what this line amendment does is that it makes clear that landowners shall not solely by reimbursing the utility, I'm sorry, let me back up. So what this line amendment does is make sure that it's an understanding that if there is an agreement that the easement is not apportionable, that should be rule of law, that will be controlling, and not to this framework allowing,
That if the easement is what?
if it's apportionable, if it's able to be divided, what our bill does is it creates a framework of how broadband can be added to already existing utilities. So what the concern was that if there's property owners who already have an agreement that the easement is not to be divided, not to be apportioned, which one controls? And this line amendment makes it clear that if there's an agreement that says that the easement is not able to be divided, not apportionable, that controls, and not this bill.
Okay. All right. At first, any questions of the paper? I think we just adopted, oh, yes. We need to adopt the line amendment on line 153. All those, there's a motion. Do I hear a second?
Second.
All right, a second to adopt the amendment. All those in favor say aye. Aye. All right, the substitute as amended is before us.
Mr. Chairman,
Senator Overchain.
you know, as some of the bills flew out of here in the first half, there's, as we've discussed a couple of times, there's an awful lot going on. And I do know that there's some people here who have some constitutional concerns, so I just wanted to slow this down just a little bit so that they could raise those issues. But
okay. All right, those who want to speak in support of the substitute as amended.
Mr. Chairman,
Senator Spruill.
so the bill now is the same as, merged the same as before, right? The one that we passed?
It's similar with the exception of an amendment.
Okay, thank you.
Mr. Chairman, Senator Spruill, the bills, as they passed, their respective chambers were identical. This is a new substitute as well as an amendment.
Okay.
Mr. Chairman, Andrew V. Horn on behalf of the electric co-ops. I want to thank Delegate Carol Foy and Senator Lewis for working with us on this bill and all the stakeholders that have come together to hopefully bring peace in the valley. We support the bill.
Okay, thank you for keeping it brief. All right.
Mr. Chairman,
Are all of you in line in support of the bill? Okay, go ahead, just your name and.
Sure. Mr. Chairman, Evan Feynman from the Governor's Office. I want to thank Delegate Carol Foy and all the stakeholders that worked really hard, and I just want to emphasize here, there is no taking of property on the part of the landowner. The utility either controls the easement and has the ability to delegate that control to another, or they don't. In the same instance, an example that was used before this body before, if you've got an easement to use a driveway, you can let your neighbor or your cousin drive on that easement as well. Thank you.
Mr. Chairman.
Senator Overshain.
If it's an easement that is limited to laying electric utilities in the easement, that doesn't allow somebody to drive on it, does it?
Mr. Chairman, I would respond to the senator by saying that there's already language in this legislation that says that if the easement expressly limits the terms of the easement, then that controls. It's merely where the easement is in its entirety that it can be subdivided to allow another person's access.
So it doesn't, so what it says is if I grant an easement to utility A, not an electric easement, not an easement for telephone service, but I grant an easement, that's all that this covers. It says that can put fiber in there too.
Mr. Chairman, Senator, this only applies to utility easements. And so where there's an electric utility that already has an easement, that, where it's either aerial or underground, then this would allow that utility to permit that easement to be used for the provision of telecommunication services, not a walking trail, not a driveway. That was merely an analogy.
I understand, Mr. Chairman. So if it says I grant an easement for electric, for putting an electric line underground across my property, this isn't going to allow that utility to put fiber underground in my property.
Mr. Chairman, no, it would not. So I don't want to be honest with this. If the electric utility were for the purposes of electric grid modernization or some other electrical purpose interested in putting fiber, I believe they would be able to do that because that would be a portion of their work to manage their grid, and that's frequently something that's going on. But no, this wouldn't permit, if it's an express easement only for electrical utility work, then this would not permit that.
Okay. Next.
Mr. Chairman, members of the committee, Kyle Shreve with Virginia Agribusiness Council. We support the bill and thank Senator Lewis and Delegate Carol Foy for bringing it forth.
Mr. Rust.
Mr. Chairman, John Russ for Dominion Energy. We've had a lot of work on this bill to try to bring it to this. There've been a lot of changes that the delegate and the senator have made in their bills, and we appreciate it very much and thank them for the work they've done to make this come together.
Mr. Chairman, members of the committee, Benjamin Knotts with Americans for Prosperity. We are big advocates for property rights. We believe in people's sovereignty over their land. Our legal scholars looked at this. Our legislative team looked at this. They didn't see any of the issues that some have brought. They could see that how that's open to interpretation, but legally they feel like this is a good solution.
Okay.
Mr. Chairman, members of the committee, Andrew Smith, Virginia Farm Bureau. We support the bill and thank the patrons. Thank you.
Mr. Chairman, Ray Lemure with the VCTA, the Broadband Association of Virginia, and we support the bill.
Okay. Is there any opposition?
Chairman Sasslaw, Senators, my name is Paul Gilbert. I'm the Executive Director of Nova Parks, which is the Northern Virginia Regional Park Authority. We have a 45-mile trail called the WNOD that we have underground fiber optics. We generate over $1 million that supports that full operation, a staff to take care of the trail, improvements. In the early 2000s, Dominion tried to take those rights away from us. It went all the way to the Virginia Supreme Court. They lost in every level of court in Virginia. And this bill looks like it is trying to reverse that and take those rights from the landowner and give them to the holder of an electric utility. I would think it doesn't look like a good bill to me. I would suggest that it be carried over and studied because this is a bill with a big impact on property rights. And it's not just us, it's hundreds of property owners across the Commonwealth that have electric utility lines going across that this bill would give those electric easement holders the right to do fiber optics and other broadband things without compensation for the landowner. So, thank you.
Next.
Michelle Gowdy from the Virginia Municipal League, and I first want to apologize for not speaking to the delegate. We came by your office and weren't able to meet with you, so we apologize. As you recall, in 2012, many of you voted for the constitutional amendment that talks about private property rights and the fact that they're entitled to just compensation. There actually is a case out of New York that is particularly relevant to this, where a cable was put on an apartment building because of a mandate in a local ordinance, and the judge actually said that was unconstitutional because it was a permanent fixation in the property without just compensation. And so for those reasons, VML opposes the bill. We also understand that there are many other issues with the constitutional part of it. Thank you.
Mr. Chairman, members of the committee, Mike Sherman with the County of Henrico. I'll just echo Michelle's comments and we have opposed it for those reasons as well.
Mr. Chairman, members of the committee, my name is Stephen Clark. I'm an attorney with Waldo & Lyle. I represent property owners in eminent domain cases across Virginia. We do believe this bill affects an unconstitutional taking of property, and I really think for the benefit of the members of the committee, the distinction must be between whether an easement can be apportioned or not apportioned. And there are two cases from the Supreme Court of Virginia on this issue. The Hayes case, in which the court determined that that easement could be apportioned, and then subsequent to that was the Northern Virginia Regional Park Authority case, which you just heard from, where the Supreme Court said this easement could not be apportioned. The issue here is whether the right to control private property is going to remain with the property owner or with the easement holder. So we asked the court, we asked the committee to pass the bill by. Thank you. Mr. Chairman. So, Steve, so you believe if we pass this, it's going to be subject to constitutional attack, and if somebody, a utility were to utilize it to lay fiber, that it may be, I guess, a business opportunity for firms like yours? Mr. Chairman, Senator Robinstein, I do think it is subject to constitutional attack. As much as I would enjoy taking this case on, I would rather not have to deal with this issue.
Thank you.
Okay, next.
Josh Baker with Waldo and Law. I represent property owners. This bill is an unconstitutional taking. It is going to authorize every single electrical easement in the Commonwealth to be rewritten. This amendment language does not actually cabin that. What's going to happen is you're going to have unconstitutional takings. The law of easements is being completely rewritten. They have some crazy definition of prescriptive easement, which is not a prescriptive easement. A prescriptive easement is an easement that's taken over time by a specific user for a specific use in a specific location. This bill absolutely upends that definition. That's a definition that goes back to England and probably before. This bill is unconstitutional. It will bring an unconstitutional change to our statutes. The 2012 constitutional amendment forbids private takings for profit. And that's expressly what is going to happen with this bill. This is a bill to expand a subscription base. They're not going to give broadband away. This is an unconstitutional taking for profit. You should turn this bill down.
Mr. Chairman, Shane Murphy. I'm a land use and eminent domain attorney in Northern Virginia. Also oppose this bill. An easement, as most of you know, is essentially a private agreement between a landowner and, in this case, a utility. When we negotiate with VDOT, for instance, for utility easements, we typically negotiate with them for multiple utility easements because there's a recognition that if we negotiate for just a power easement, that's all they get. So what this bill essentially does is it unilaterally expands what is a private agreement between these utility companies and a private landowner. And in the Northern Virginia region where we live, I understand what it's intended to do for rural areas who need broadband, and I accept that. In Northern Virginia, we're having our streets dug up every other day for another broadband provider to come in. And this bill would allow in Northern Virginia these utility companies to essentially come in and instead of going through the trouble of using the streets, they could use the power corridors. And it would have a substantial impact on property owners who want to redevelop their property. They'd have to move all of this ductwork without having been compensated for it being there in the first place. There's just a lot of concerns, I think, that need to be resolved before this can move forward. And again, I don't mean any harm to the folks in rural Virginia who do deserve to have broadband. And I would say, I'm not sure if any of my other opponents would agree with this, but I think the way to do this is to explore giving eminent domain authority in some form or fashion to folks who need to do this, because that would allow them, again, the gas company's got an eminent domain authority, power company, that is what would allow them to do this the right way. So I appreciate your time. Thank you.
All right. You've heard the criticism.
Good afternoon, Senator Saslaw, members of the committee. Sam Brumberg with Virginia's Electric Cooperatives. Just to briefly respond to some of the oppositional points you have heard today. In regards to the Northern Virginia Park Authority, this bill would absolutely not touch the Park Authority's revenue stream. It has been adjudged by no greater authority than the Supreme Court of Virginia that easement was not apportionable. It was very clear in that case what happened. We are not disturbing that precedent in any way. As to damages available to landowners, the landowner is entitled to actual damages based on a trespass claim. If there is a problem, if there is a landowner who thinks she has a claim, please let her go to court and be compensated.
Mr. Chairman,
Senator Obenshain.
and I want to support you. Believe me, I really do. But aren't there two questions with respect to a taking? Number one is whether it's even allowed. And number two, what's the fair compensation? So can you address the number one?
Yes, Mr. Chairman, Senator Obenshain, I would you heard from some of our opponents regarding two different cases, the Hayes versus Bart case, which this bill certainly leans in that direction, and the Northern Virginia Park Authority case. In the Bark case, it was very clear that the easement was apportionable, and I would refer the committee to line 33 in the substitute, which clearly states the easements affected by this bill are those with right of apportionment. We're not trying to take rights that we don't have. We're trying to create a framework to share rights that we do have. So the Hayes case, again, was not electric on electric. That was an apportioned prescriptive easement to Virginia Telephone Company and Bath County Cable Company. Just in regards to some other things you've heard this afternoon, the Loretto case, again, the Loretto case cited by Virginia Municipal League, we believe is inopposite, given that that was a direct mandate to enter onto property, whereas in this bill, we are contemplating utilizing existing easements where facilities already exist. I would just reiterate, we are not trying to rewrite easements here. A private agreement between parties will always govern. I would submit to my friends in Northern Virginia that there may actually be less digging up of the streets if we can utilize existing easements in this way. And
Mr. Chairman, I'm sorry.
Senator Overshaw.
So, and I'm about 45 seconds behind you, so I apologize. I'm trying to keep up. So it does say that an easement means an existing or future occupied electric distribution or communications easement with the right of apportionment. But then it says it includes a prescriptive easement, and you go on and have a definition of prescriptive easement down there that seems to include if there's been a utility easement across my property for more than 20 years, it just automatically becomes a wide open easement. So if I had a easement for electricity across my property and it's been there for 20 years, I can't challenge. It is automatically under this a prescriptive easement that's not subject to challenge?
Mr. Chairman, Senator Obenshain, I would say to you that no, you could challenge the existence of the prescriptive easement. I would refer you to line 96, where the bill clearly states nothing in this section shall diminish a landowner's right to contest the nature or existence of a prescriptive easement. And I would refer you to the Hayes precedent, which indicates...
Whoa. Stop. I don't know that you're reading the whole thing to me. You can challenge the nature or existence of prescriptive easement that's been there for less than 20 years. How about one that's been there for 21 years?
Well, 20 years is the prescription period for a prescriptive easement, but if there were some other issue with that easement, again, in an overhead situation, I think those cases are much easier to call because the facilities are right there. But if there were some other issue with that prescriptive easement,
Like that it only is for electric power?
certainly the landowner could take a case forward and argue that to a court and get actual damages for that trespass if there were one.
But you're not going back to my first question about whether it is even constitutional to engage in a taking under our constitutional amendment if it's a for-profit corporation and that taking would benefit the business.
Mr. Chairman, Senator Obenshain, and apologize trying to take in all of the issues that
I'm doing this on the fly
intern.
too, I'm sorry.
I understand, and I beg your indulgence. I would say in that situation where there were a prescriptive easement, the landowner certainly could challenge that in court if she wanted to. I would just cite to you the Hayes case where you had an electric easement that had run an overhead electric easement that had run the prescription period. In that case, the telecommunications facilities had been in place for, I believe it was 13 or 16 years, but just a few years less than that period. The court found that the utility in that case had exercised exclusive domain over that easement for the prescription period. And as a result, that prescriptive easement was apportionable to the attaching entities, Virginia Telephone Company and Bath County Cable, represented capably by none other than Senator Deeds.
Mr. Chairman, Mr. Chairman.
Mr. Chairman. Mr.
Yes,
Chairman.
sir. I'm sorry.
Go ahead, John.
Mr. Chairman.
Talk to me up.
Here's for anybody, the three things I want to read. The utility in this bill, utility services is added to include, it means any products related to energy quote, broadband and other communication services, end quote. That's what utility services is defined to mean. In addition, it goes over here about easements. Easements means, this is new language, means in this bill, an existing or future occupied electric distribution or communication easement with right of apportionment, right? And then it goes on to say, it is a policy of the Commonwealth that easements may be used to expand broadband, and the use of easements to expand broadband, et cetera, is in the public interest. This is what the bill says. Now, why is that not legal and constitutional?
Mr. Chairman, Senator, I would say that it is constitutional.
Look, I got a question for you. When the house we live in, we had built, we still have Cox Cable. And Verizon was in a couple homes on the block. It was a new street. They wanted to, and I'd already had grass and everything, the driveway poured. They wanted to come by. They want to use, I guess, the existing easement that probably Dominion had, come across my property to get to the next house. Under your bill, would that be allowable?
Mr. Chairman, if I may ask.
Does Dominion then say to them, or whatever, yeah, you can use our easement?
Mr. Chairman, if I may ask, what year was your house constructed, or roughly?
2009.
Okay, so I do know, and I would ask my friends from Dominion Energy to correct me if I'm wrong here, that post-2006, Dominion routinely enters into non-exclusive easements. And in that case, I would submit to the committee that this bill would not apply and that a new easement would be necessary.
Mr. Chairman, I do believe that the Senator Davis case that you referenced was decided before the constitutional amendment was adopted. And the Supreme Court had much greater latitude in allowing condemnations in the public interest, even if it benefited a private party before 2013. Isn't that right? I mean, that isn't a valid precedent, is it?
So if I may, Mr. Chairman, what this bill does, it does not address condemnation. It is not about eminent domain. It is not a taking because the government is not involved in doing any of these things. What we are actually doing is creating a framework to say that utilities, you have this ability and this is how it's to be done.
But this is the government action. This is what's affecting the taking. It's not what the utilities are doing, it's what we're doing. So it would be our action that, I mean, if it's unconstitutional, that would allow utilities to affect an unconstitutional taking.
So, Mr. Chairman, what I would say to the senator is that what happens in this bill is that there are some definitions that's used. However, prescriptive easements are already established and addressed by case law, that it has to be open, adverse for 20 years. So even though it's enumerated in the actual bill, it's already established by case law. So we're not establishing anything new here. What we're saying is definitions are commonly in our code, and these are the definitions, and this is how it will apply. It's simply a framework, a process of how we can actually get broadband attached to already existing utility easements who have the authority, the ability, the capability to divide their easement to someone else.
All right, we've been on this bill for quite a while, so we need to wrap things up.
There's a report.
There's been a motion and a second to report the substitute as amended for House Bill 831. Motion second. All those in favor vote aye, those opposed nay. Bills reported.
Ayes 11, noes 2, 2 abstentions.
Right. Senator Delegate Foy.
Yes, Mr. Chairman.
Let me take Delegate Lopez, because he's got to chair a subcommittee, and then we'll come right back to you.
Yes,
Okay?
thank you, Mr. Chairman.
Is that all right?
Yes, Mr. Chairman.
Good afternoon, Chairman Sassel and members of the committee.
Okay. Your bill is
HB 358, Mr. Chairman.
HB 358. Okay. Project labor agreements. Let me tell you, Delegate Lopez's bill is what my bill was when it got voted out of committee, pretty much. And the vote was 12-3. Then it got amended on the floor, which totally kind of turned it around. But as I said before, Delegate Lopez's bill dealing with project labor agreements is pretty much similar, if not identical, to mine.
Yes, sir.
When it left committee. So you want to briefly just, and very briefly.
Yes, sir. In a nutshell, sir, this bill there's currently no option in Virginia for state entities or localities to issue PLAs for public works. This bill simply restores to all public bodies at the state level and local level the option of utilizing PLAs on their construction projects. That's essentially it, sir.
It was pretty much the same, until mine got amended. In fact, I think almost identical. All right.
Mr. Chairman,
Senator Spruill.
is there an amendment to this bill anywhere? I was told.
Is there what?
An amendment?
Well, no, there
Substitute?
is not right now. There may be on the floor. Senator Marsden is working on something, but we need to get things moving. So, or we're never going to get out of here. So, you all have heard this. I mean, we had a fair amount of testimony on mine. Senator Evan?
Yeah, Mr. Chairman, unless there's discussion, I'd move that we get it out in the same posture it left before, which would be to report.
We'll leave his bill alone.
Yeah, report Delegate Lopez's bill as is, yeah. That'd be my motion at the appropriate time.
Yes, we've heard all the arguments before. If you're in favor of the bill, raise your hand.
Mr. Chairman?
Yes.
So are you saying that on the floor that there would be an
There
amendment?
might possibly be an amendment. Can't guarantee it, but there might possibly be. Okay?
And I'd be happy to actually have a conversation with Senator Spruill at any time.
Law remain the same way it was. Yeah. Thanks, Parker. All right.
Can I move to conform so that at
No,
least
I
we can?
do not want to conform to mine. So.
I can't move.
All right. All right, is there a motion to report?
I made that motion, sir.
Second.
All right. Is there a second?
No, second.
There's a motion and a second to report House Bill 358. All those in favor vote aye. Opposed, nay.
Ayes 8, noes 3, abstentions 4.
Goodness.
Bill's reported, barely. Well, actually.
Thank you, Mr. Chairman.
Okay. All right, Delegate Foy.
Thank you, Mr. Chairman. My next two bills are really easy.
Next one is what?
House Bill 123, the non-payment of wages.
Okay. That is similar, not identical, to Senate Bill 838, Senator Evans' bill, which passed here 12-2 in committee and 22-18 on the floor.
Yes, Mr. Chairman, and I have a line amendment.
That's what you had the last time. It took about an hour. Hold on here. Why don't you go and explain your bill?
Yes, Mr. Chairman, members of the committee. What my bill does is address this wage theft epidemic across the Commonwealth, as evidenced by a 2012 JLARC report that showed a quarter of Virginia employers commit wage theft against their workers. The same report found that approximately 214,000 workers were taken advantage of by their employers. And more recently, the Virginia Employment Commission revealed in a report from the Governor's Task Force that the number of workers that are victims of only one form of wage theft in Virginia every year is close to 400,000. And despite the wide-ranging extent of the wage theft in Virginia, workers in the Commonwealth have strikingly few options to recoup lost wages. If an employer misclassifies a worker, the sole remedy is to file a complaint with the understaffed Department of Labor and Industry. Even if a worker is successful in their claim, they may only recoup back pay, no damages, and no attorney's fees. So this bill addresses that issue and actually allows for a person who has had their wages stolen or overtime not paid or whatever the issue may be to be able to not only recover back pay, but damages and attorney's fees.
Mr. Chairman.
Senator Ovington.
On the floor, we had a robust discussion about lines 40 through 42 and amended that bill on the floor to strike that. Would you object to striking that?
I will not. That would be a friendly amendment, and that's exactly what my requested line amendment would do, sir.
I'm sorry if I
No
didn't hear
worries.
you. I apologize.
No worries.
I would move that amendment.
So that deletes
40 through 42.
40 through 42, lack of privity. Okay. All right, you've heard the amendment. All those in favor, vote aye. Aye. Opposed, all right. So 40 through 42 is deleted. All right, bills before us in essentially
Move report.
same form. Second. All right, there's been a motion and second to report House Bill 123. They're calling for it to go to finance. What, do you remember, Mr. Stevens, whether that was, I mean, Evans came out, so there must have been money in the budget. Okay. All right, well, we'll send it up. The motion will be report and refer to finance.
Yes, sir.
Okay. All right, all those in favor of reporting and referring to finance, vote aye. Opposed? All right.
Ayes 12, noes 3.
Thank you, Mr. Chairman. Members of the committee, my last bill is House Bill 833, prevailing wage. Mr. Chairman, before I begin, I'd like to move my last line amendment.
All right, hold on. All right, 833 was similar to my Senate Bill 8 that dealt with prevailing wage rates, and it was, I think we put a $250,000 minimum on my bill. You want to do the same thing?
Yes, sir. That is
All right.
exactly what the amendment does.
So, all right, it's been moved and seconded that we add the $250,000, which pretty much conforms it to mine, threshold on the bill. All those in favor of adopting the amendment, say aye. Aye. Opposed? All right, the amendment's adopted and the bill is before you. Mine did have the clause, but it's they funded it. They said it's 103,000 is in the budget. Yeah, no, the money's in the budget on our side, anyways. Is it on your side?
I believe so. Yes, it is on our side.
Okay. All right. The motion will be just to report to the floor. House Bill 833. All those motion is.
So moved, Mr. Chairman.
All right. And a second. Do I hear a second?
Second.
No, you gave the motion. All right. All right. Senator Evans seconds it. All those in favor of reporting House Bill 833, vote aye. Those opposed, nay. All right.
Thank you, Mr. Chairman. Thank you, members of the committee.
All right. Next on the hit parade is Delegate Bulova. Delegate Aird, you're on deck. Okay?
Thank you much, Mr. Chairman. This is House Bill 508. What it does is it removes the fee for placing a security freeze on your credit report. And before anybody gets too excited about this bill,
You said 508?
509, I'm sorry.
509. Yeah,
509.
that's what I had. Okay.
Yeah, so a short, tragic story for you. So our original security freeze legislation passed in 2008 allowed a $10 per freeze. And then in 2018, we took that down to a $5 per freeze amount. And so I was really excited this year that we're going to finally get that down to zero and make sure that you don't have to pay money in order to be able to protect your family from identity theft and fraud. Last, when I was visited by the lobbyist for our credit bureaus, expecting them to come after my bill, they said that in 2019, the federal government beat us to the punch. And so what started off what I thought was a really great bill is now simply a code cleanup bill to ensure that our Code of Virginia now aligns with the federal definition and that there is zero charge. I guess the one consolence in all of this is that if the federal statute ever goes away, we'd still be able to protect our consumers here in Virginia. That's what the bill does, Mr. Chairman.
Move to report. All right, it's been motion second to report 509, House Bill 509. All those in favor vote aye, those opposed nay. All right.
That's 15-0. All right. Thank you very much, Mr. Chairman.
All right. Delegate Aird, you're up. And Delegate Price, is Delegate Price here?
Yes.
Delegate Price, you're on deck.
Thank you.
Good morning, Mr. Chairman and members of the committee. Before you is House Bill 689. Mr. Chairman and members of the committee, House Bill 689 is simply a technical fix to legislation we passed last session, Senate Bill 1696 and House Bill 2664, which was the requirement for all employees to receive pay stubs. So all we're trying to do is add in some clarifying language to make sure that employees who should be paid by wage aren't being classified as salary, so that they are not cheated out of their money. I hope it would be the pleasure of the committee to move the bill forward.
Mr. Chairman?
Okay. Senator Reben?
So just to ask the delegate, it looks like just from reading the bill, it's just whether or not they're a full-time employee or an independent contractor, that's all you're asking? Would it be
Full-time or wage?
Or wage employee, whether or not that's indicated will be on the pay stub?
Yes.
Okay. Thank
Technical.
you.
All right, any other questions?
Yeah, just real briefly.
Senator Reben.
So if I've got a wage employee, and I may be really dense and not understanding this, I am really dense, but I'm not understanding it. Do I have to report the number of hours worked by wage employees
It's my understanding that you already have to do that, but
on their pay stub? Yeah,
yes.
wage employees.
Yeah, I can just tell you, professional company,
So I know most law firms bill by the hour, but if they don't, and you've got highly compensated people, you've got to keep track of.
They're lawyers, though, that's different.
We are special.
Mr. Chairman.
Senator.
Mr. Chairman, I'd ask the patron, where does the language, it looks like added in the House on line 55 come from?
I'm sorry, can you repeat that?
Sure. Looking on line 55,
Yes.
where does that language come from and what are you trying to cure? So you have to explain the calculation or help me just understand that amendment?
I'll phone a friend.
Okay.
So the bill that was passed last year basically says that
you have to explain the hours. And so folks came back and said, but what if we have salaried employees? So what the change does, it says you don't have to report the hours if they're salaried unless they're under the FLSA threshold. And the FLSA threshold was raised in January 1 of 2020. And so you have to make sure that folks are under that threshold in order to not be subject to the overtime requirement. So it's just a fix for the bill to make it easier for people who do pay salaries that are above the threshold to not have to report hours.
And you asked where the language came from, and this was brought to us by accountants who were actually trying to implement the legislation that passed last session.
Mr. Chairman, maybe what we do is work in between now and the floor if it gets there to see if how difficult it'll be to place online how the calculation is made, right? And I just don't know. I mean, employers are out there day in and day out trying to make it, and just want to make sure that that is a doable thing. So that's all my question.
Mr. Chairman? To me, it sounds pretty simple. Just to take an example, my first job was at McDonald's, and if you want to look, you would put the number of hours that you worked, and then you would multiply that by the hourly rate, and the check would make that clear. Whereas if you worked a job that maybe was above 40 hours a week, or that paid above what you would make at the minimum wage times 40, and it was not an hourly job, it would just say what that salary was and what the deductions were. Just basically the kind of pay stub that we're probably used to reading, except if you're hourly, it might be your employee.
Yeah. Thank you, Senator Evans.
All right. Anyone want to speak in favor of the bill out there?
Move report.
Well, hold on. Anyone in opposition? Anyone even care? All right. All right, bill's before us. Is there a motion?
I second.
All right, then a motion and a second to report. House Bill 689. All those in favor, vote aye. Opposed?
I thank the committee.
Ayes 15, no zero.
All right. Delegate Price. No, that doesn't have to go to finance. Delegate Price, you're up. And
yes.
Delegate Willett. Is Delegate Willett here? Yeah, but he's down.
Mr. Chairman, my bill is.
All right, I'll take him. Delegate Sickles, I didn't see you. You've been here a while, so you'll be next. And then Delegate Willett will be after you.
Yes, Mr.
Go
Chairman.
ahead, Delegate Price.
My bill, I think 337 is the one that was not in the block. That is identical to Senator Spruill's. I think I am just waiting for the dreaded clause.
What?
We add the clause. I move the clause.
Second.
Is a clause on,
It's on mine, it's on my bill.
I'll see you in Congress.
what's your bill number?
337.
337. So that's similar.
Page 4.
That's not identical. That's similar.
Other than the clause.
Okay. All right. All right, there's a motion and a second to add the clause to House Bill 337. That way we don't have to send it to finance. That means that there's going to have to be money in the budget in order for your bill to take effect.
It is there. In both.
Okay. All right. All those in favor of House Bill 337 as amended with the clause, vote aye. All those opposed, nay.
I thank the committee.
Okay.
Ayes 15, no zero.
Mark, you're up.
Thank you, Mr. Chairman, members of the committee. I've got a technical bill from the SCC, Bureau of Financial Institutions, HB 155. I hope Joe's here. Yeah, Joe's here.
155.
Yeah, it's a bill in the banking code section that right now describes how a bank can take a trust that they have fiduciary responsibilities for and serve it in another bank that they already own. And this bill just adds something that's called, on line 38, a trust subsidiary under common ownership. And it has that same 80% or more threshold that another subsidiary bank has to be able to be, the trust be moved back and forth. So it's a technical bill. The banking industry in Virginia supports it, and I can't.
Give me an example of how this bill works.
Well, I don't know why.
Here comes somebody who can
Okay.
bail you out.
Mr. Chairman, Joe Face, Commissioner of
Welcome,
Financial
Mr.
Institutions. We had a situation last year where one of our large state chartered banks wanted to consolidate into one organization, but they had a trust subsidiary that was not part of the organization,
Not part of the bank.
not part of the bank. And because the trust was not a bank, it could not merge into the bank. It had to be a bank into a bank. So what they had to do was go to the circuit court and get approval from the circuit court to merge the trust company into a bank. As far as I know, that had never happened before. It was an unusual situation, but the code required them to go to the circuit court. We think they should come to us. If it ever happens again, that's what this bill does. It requires them to come to us and we'll approve it. There was no issue other than that.
That makes sense. All right, any questions by the committee members of the patron? Any opposition to this bill? Second. All right, it's been a motion and a second to report House Bill 155. All those in favor vote aye. Opposed, nay.
That's 15-0.
Thank you, Mr. Chairman. Now I have the Virginia Health Benefit Exchange Bill, HB 1428. And, Mr. Chairman, members of the committee, this bill is a moving amendment process. We need to have technical amendments. It's an important bill to the process over the next 3 years to move from healthcare.gov to a new state-based exchange. And I would, I don't know how much you want to go into. You probably heard testimony on this before.
You had told me bye for the day.
Well, if you could, I think because of the deadlines going up to the Finance Committee, if you could just lay Senator McClellan's version on it and send it to Finance, we could just take care of it up there.
It's similar to McClellan's.
It's was word for word at one time.
Mr. Chair, I move to conform this to Senator McClellan's Senate Bill 732.
Senator McClellan's, for your information, passed this committee 12-3 and 29-10 on the floor. All right, you've heard a motion to merge, to conform Senate Bill 1428 with Senate Bill 732. Is there a second? No. All right, it's moved and seconded that we conform House Bill 1428 with Senate Bill 732. All those in favor of doing that, say aye. Aye. Opposed? All right, it's.
Thank you very much.
It's amended.
Okay.
Wait, it's got to be reported.
Oh.
Hold on here, Chief.
Okay.
Okay. It doesn't show on here going to finance. Is that in the letter? All right, the motion would be to report.
Mr. Chair, I move to report and re-refer to finance.
All right, is there a second? Second. All right, all those in favor of reporting and referring to finance, vote aye. Opposed, nay.
Thank you very much.
All right. Is that it for Senator,
That's it.
for Delegate Sickles? Okay.
That's 12 noes, 2.
All right, now Delegate Willett.
Good afternoon, Mr. Chairman, members of the committee.
Is Delegate O'Quinn here? Delegate O'Quinn, you're on deck.
Thank you very much, Mr. Chairman. This is HB 1553, which creates or gives to the SEC licensing and regulatory authority over companies that offer debt settlement services. There's a need for this bill due to the fact that right now this industry is not regulated, and there are a number of Virginians that have complained to the SEC and the Attorney General's office about excessive fees that they've had to pay for the services. In a nutshell, these services or companies will come in on behalf of a credit card holder that has debt with one or more companies. They will negotiate that debt down. We believe that this is a reasonable bill, a consumer protection bill that sets fees for that, caps those fees, but provides a means for these companies to still function in Virginia, but with the oversight of the SEC.
Okay, are there any questions of the patron of the bill? That's House Bill 1553.
Mr. Chairman,
Senator Newman.
what's the limits in your bill, and what is the national limit?
Yeah, so the limits in this bill, there are actually two limits, and there's an option provided for industry. So one limit is set to 15%, and that's where you would be looking at the total amount of debt that's enrolled. Let's say you had credit card debt of $10,000, and that amount was what they were starting from in terms of negotiate. So 15% there. The other option, which is the or here, is a 30% limit on the debt, the actual savings. So if you had a $10,000 debt, $5,000 was saved, you would pay 30% on that $5,000 savings. This limit is actually just above the national average or national median, so it's on the high side of that. We adopted what was done in Minnesota. It looks there that they've had great success with this in terms of the number of companies that are still offering the services, but doing so in a fair way.
Mr. Chairman,
Senator
is the national level at 25%, not the average, but is the federal level at 25%?
I'm not versed in all the numbers nationally, but I do know that the AG's office worked on this and then made their recommendation for the legislation based on looking at those averages.
We'll check and see. Thank you.
Yeah.
All right. Those who are in favor of the bill?
Mr. Chairman, members of the committee, my name is James Scott, Assistant Attorney General, Consumer Protection. Attorney General Herring supports this bill. It's one of his priorities. The reason for that is 34 other states currently regulate this industry. Virginia does not, and for that reason, the industry charges far more here than it does for providing the same services in other states more cheaply. To answer the question that was raised before, there is no national fee cap. The FTC looked at maybe doing that back in 2010, decided that it could not do that because it wasn't authorized to do that. That's why we see 34 states in the nation that have actually licensed and regulate this industry, and why they're fee caps. And as Delegate Willett mentioned, 15% of the debt enrolled and 30% of savings is the same fee cap that's been in place in Minnesota for the past decade. In 2018, the industry actually settled $50 million in debt in Minnesota, so clearly it didn't return from Minnesota. So we believe there's a reasonable fee cap. We've worked very hard over the past 2 years with the SEC to craft this bill so that the SEC is comfortable from its, from the future position of being the regulator. It's a strong bill. We urge you to support it. Thank you.
Jay Spear with the Virginia Poverty Law Center, and we support the bill. This, from our experience with legal aid, this is a real big problem. These debt management companies take advantage of a lot of folks in desperate situations, and they do need to be regulated. Thank you.
Okay. Anyone in opposition to the bill?
Thank you, Mr. Chairman, members of the committee. My name is Steve Baums. I'm with the American Fair Credit Council. We're the trade association for debt settlement nationally. A couple of things. First, there is no national fee cap. Moreover, while regulation at the state level is something we support and is common in other states, fee caps for debt settlement are the exception to the rule. While there is widespread regulation at the state level, it is not the case that the majority of states have fee caps. Moreover, while there was some debt settlement activity in Minnesota, where the fee cap that is in the bill as passed by the House exists, it was only about a third as much activity on a per-person basis as we saw in Virginia last year. In Minnesota, for example, there was about $18 million net savings for consumers last year. In Virginia, there was about $60 million net savings. And so while we are fully subscribed to the notion of a state regulatory regime that adheres to the federal rules, which put the consumer in control at all times, we are opposed to the fee cap that's in the bill. Thank you very much.
Mr. Chairman?
Senator Morrison.
Thank you. Is it your experience in states that when there is no cap, that the different companies compete for business to make it better for the consumer, as opposed to one size fits all and every company has to charge the same rates? Is there any advantage, I guess is what I'm asking, to have that kind of competition?
Mr. Chairman, Senator, we think so, and not only do we think so, that was the experience in Maryland. Maryland in 2012 passed a state regulatory bill that asked the state regulator to do a study over 4 years and report back on whether fee caps were necessary. After that 4-year period in 2016, that's precisely what the state regulator found. No fee caps were necessary because competition made for competitive pricing.
Thank you.
Delegate, former delegate, welcome.
Thank you, Mr. Chairman, members of the House, members of the committee. Dave Albo representing the Fair Credit Council. We like the bill. Fair Credit Council is the organization of debt settlement services. We like the bill. The only dispute is about whether there should be a fee cap or not. And for those of you who I was unable to talk to, let me just explain to you what debt settlement services do, and then you can understand why a fee cap is not necessary. So let's say Dave Albo has a catastrophic economic event, like I get divorced, I have a medical bill, I'm in the House of Delegates and I make $17,640 a year, and I rack up a $20,000 credit card debt. After paying my house and my car and my insurance, I can't really make my payments, I'm starting to get behind. I call the credit card company, said, hey, can you cut off half of it? And they go, click. So what I do instead is I call a debt settlement service company. Debt settlement service companies are regulated by the FTC. The rules say that the debt settlement service company can't touch my money. All they can do is negotiate on behalf of me. So I call them up. They ask me to set aside, to create a savings account. And when I get to, say, 40% of my debt, then they will start negotiating with a credit card company. The credit card company talks to the debt settlement services company because the debt settlement services company has already done a financial analysis. They know the person can probably pay a certain amount, and they've gone through all the triage. So when the debt settlement service company calls a credit card, said, will you take 20%? Credit card says no. Will you take 30? No. You take 40. Okay, we'll take 40. What the law says is that the debt settlement service company then has to call Dave Albo, tell me what the savings is going to be, and tell me what the fee is going to be, and then I can say no. That's federal law. And in Delegate Willett's bill, I'll draw your attention to line 254 and line 293. They say the consumer may withdraw from the debt settlement service at any time without penalty. It says it twice. So it is impossible to have an aggrieved customer because the customer has to agree to the settlement and the payment, and they can walk away without penalty at any time. What I would suggest would be a better way to do it would be to use the, if you want to have a fee cap, which again, we don't think is necessary, but if you do, you could use the current status quo, which is 25%. I had talked to the SCC about whether they could set a cap, and they said they're unable to actually set a cap, but they can report. So I think what would be a good idea would be to have the SCC, so you keep the status quo what it is right now at 25%, have the SCC report back to the committees with statistics, so if a fee cap is necessary, you can actually do it based upon science and data instead of a bunch of guys like me trying to make up a number by pulling it out of a hat.
Mr. Chairman,
Go ahead.
Senator Spruill.
question two.
Yes, sir.
How you doing?
Good.
You brought up the fact about if a person makes $17,640 and then it debt up $20,000 in debt. Is it normal that a credit card company or any lending institution will allow you to borrow more than what you make a year? I'm looking at.
Well, that would be.
Why would they allow me to max the card at $20,000 when I only make $17,000?
Okay, let's make sure we're talking the same thing. Debt settlement services companies don't get people into debt. They are not payday lenders, they're not short-term, they have nothing to do with getting people in debt.
Okay.
What they do is they get people out of debt. So I want to make sure we're not confusing the two.
I'm good, thank you so much.
Mr. Chairman.
Senator Lewis.
I think I'd offer that amendment. I think we've got it here.
At what amendment?
That we put a 25% cap and that we have it monitored for the next 3 years and report it back to us every year.
So I thought it was 15%.
It is in the bill, but my amendment's 25%.
Is this what it is in Maryland?
So Maryland has no cap.
No cap. All right, it's been moved and seconded that
Mr. Chairman?
we strike 15 and insert 25.
Mr. Chairman?
Yes.
The patient sitting there wants to say something bad. I'm hoping he doesn't agree to that. At least let him say yes or no. Let him say something.
All right.
I speak to the, yeah.
Well, I was just reading the amendment. Okay. You want to comment on the amendment?
Thank you, Mr. Speaker, or Mr. Chairman. A couple of points, just to correct a little bit of information that was shared. First of all, coming back to Minnesota, where there is a cap in place, Minnesota actually has the highest average savings for consumers with credit card debt in terms of having that negotiating amount. So they actually have had, you would argue, the best success rate because of that high average they're negotiating. The other thing I should mention, referencing the FTC does not license and regulate these companies. That's why the states that have done so are doing so, and that's why we have this bill today. There is no licensing and regulation of them. The third thing, last point I'll make to the 25%.
This just deals with a cap.
Right, and that 25% actually would be higher than what Virginians are paying today on average. That would exceed the current amount that's being paid by most Virginians on average today. And
What are they paying?
They defer to AG on that, the average.
Mr. Chairman, members of the committee, according to industry data in 2018, I believe the average would be 22%, 22 or 23% of the debt enrolled. So you would be legislatively allowing the industry to charge more if there were a cap of 25% of enrolled debt. That's why the industry is proposing this.
Mr. Chairman, that's the average, correct?
Correct.
Suppose instead of 15, he said he has 15 going to 25. Suppose he made 15 going to 20.
Mr. Chairman, I respect, again, I'm also deferring to multiple years of discussion and research on the topic, and that's what got us to the numbers. In this discussion process, we've actually amended the bill several times to get to that number. We feel like the 1530 is good by Virginians. These companies will still flourish as they've done in other states like Minnesota. We think it's a reasonable number.
Mr. Chairman?
Hold on. Joe, what do you say?
Mr. Chairman, Joe Face again, Commissioner of Financial Institutions. Of course, we have no position on the bill. We're happy to do whatever you ask us to do. I just want to make sure I understand exactly what you would be asking us to do with this amendment. Is that to gather information and report back to you on whether there should be this rate or that rate or a cap or?
Well, it says here, in addition to the effective date of the first enactment of this act, July 1st, 2021, the State Corporation Commission shall monitor settlements by all licensees, specifically looking at the number of settlements made pursuant to the act and the fees charged pursuant to 6.2-2041 as created by this act, and the principal amount to be paid by the consumer to satisfy the debt, and shall report to the chairs of House Commerce and Labor Committee and Senate Commerce and Labor Committee by December 1st of each year, 2023, 24, and 25.
We can certainly do that, Mr. Chairman.
I know you can. Dave?
Mr. Chairman, Dave, let me ask you, the 3 years seems like, a lot of time to go by. Would you consider a friendly amendment to back that off to 2 years? Let's take a look at it in 2 years instead of 3.
When I drafted it and then talked to Senator Lewis, I had talked to you about it, and originally he did 3 years, and you thought that was too long, so I did 3 one-year periods. So bill becomes effective, and then the SEC reports the next year.
Oh, it's an
the
annual.
next year, and the next year.
I got you. Okay, thank you.
Mr. Chairman?
Senator Bell.
My understanding is the average fee charged on this is 18 to 25%. Is that correct?
Mr. Bombs is here. He can answer that question.
Mr. Chairman, Senator, that's correct. The fee typically is variable depending on the size of the individual debt. Because it's the same amount of work regardless of the size of the individual debt. Under FTC rules, the companies can only be paid after those FTC three-pronged tests are met. Typically, the lower the debt, the higher the percent, the higher the debt, the lower the percent, which is why you would see in Minnesota, for example, significantly fewer settlements, but higher savings because the debts are larger.
So, Mr. Chairman, to clarify, the range, not necessarily the average, the range would be, is 18 to 25, is that
That's
accurate?
correct.
Okay, and an average, what the other gentleman said was 22?
It's equates to 23% on average in Virginia.
And what do you want it to be?
So, Mr. Chairman, I would just offer that if we're going, if the bill was at 20, it was at 15, the amendment's at 25, maybe 22 would be a better answer, because, you know, if we're gonna make, why would we set the bill below where the average is?
Mr. Chairman, members of the committee, the reason that we set the bill for 15% of enrolled debt is because nationwide, the averages are 22, 23, and Virginia is higher than that. The reason for that, there's no licensing or regulation here in Virginia. But we've seen, based on industry data, that where there is a 15% enrolled debt cap, that the industry still flourishes. There was 8,000 settlements in Minnesota in 2018 and $50 million in debt. This is, again, this is the for-profit debt settlement industry. That's.
I'm gonna make it 20. Okay, all right, here's a suggestion I'm gonna make. The language of his enactment clause will pretty much stay the same, but we'll make instead of the 15 going to 25, as he suggested in his amendment, we'll make it 20. Do I?
So moved, Mr. Chairman.
All right, is there a second for 20? All right, there's a second for 20. All those in favor of adopting the amendment offered up by David Albo, Delegate Albo, the 101st delegate, which would have the SCC look at this, Mr. Face, look at this and report back, every year on, what's going on in the industry. But the cap would be, instead of the 15 that they suggested in the bill, it would be 20, which is a little below what the average is, somewhat below what the average is now. All those in favor, say aye. Aye. Opposed?
No.
All right, one no. Senator Barker's is a no. All right, the bill is before us as amended.
Move to report as amended.
All right, and refer to
And refer to that place I'll always object to.
Okay. All right, all those in favor, vote aye. Opposed, nay. All right, your bill is reported and referred to finance.
Mr. Chairman, thank you very much.
Delegate O'Quinn. Delegate Ranson, is she here? All right, you're on deck, followed by Delegate Hurst. Is he here?
He just stepped out. He'll be right back.
All right, Delegate O'Quinn, you're up.
Thank you, Mr. Chairman. I have House Bill 1457, and this bill would amend the Virginia Securities Act to provide for recognition of the OTCQX market to give Virginia investors more information in their investing decisions. So you may or may not be familiar with the OTC market. It's in 3 tiers, with OTCQX being the highest tier. There's an OTCQB in the middle, and then the one you may have heard of at some point and may have some sort of negative connotation to it is OTC Pink. And we're not talking about that, so I'm focused exclusively on that highest tier. So if any one of us wanted to go and get advice on a company listed on this market right now, and you went to any broker-dealer, any investment advisor in the Commonwealth of Virginia, and you said, I have a community bank down the street interested in buying their stock. I think they're doing a good job. Tell me what you think. Should I buy it or not? The advisor cannot give you the advice, positive or negative, on that stock because the exchange itself is not recognized by the State Corporation Commission. So essentially, you're getting less information. So this would allow more information, whether that be a positive or a negative recommendation or just general information. There are about 9 companies in Virginia listed on OTCQX, about 1,400 employees. Most are community banks. 36 other states actually give this recognition, and more are in the works of doing so. But again, we're talking about the very top tier here, and these are companies that have stringent reporting requirements. They essentially make the same requirements of any other public company that's listed on, for instance, New York Stock Exchange, NASDAQ, et cetera. They have, there's heavy oversight, not only from the OTC internal compliance team, but also from the Securities and Exchange Commission, the Financial Industry Regulatory Authority, and then, of course, in Virginia by the State Corporation Commission. So through several drafts with the commission to get the language into the posture that they were comfortable with. I appreciate their help and happy to take any questions.
Any questions? All right. Anyone in the audience want to talk about the bill?
Mr. Chairman, members of the committee, Matt Bernier with the Virginia Bankers Association. This would provide access to some additional investment opportunities for some of our community banks that are traded on the OTCQX market. So we support the bill and appreciate the delegates' efforts.
Okay. Anyone opposed? All right, the bill's before us. All right, it's been a motion and a second to report House Bill 1457. All those in favor vote aye. Opposed, nay. I think that's your only, no, you.
Ayes 15, no zero.
Yeah.
Thank you, Mr. Chairman.
Okay, we voted out your other bill. All right. Damn it. Okay, next is Delegate Ransom. Delegate Hurst, you're next.
Thank you, Mr. Chairman. Members of the committee, I have House Bill 951.
Hold on here. 951. Here.
There is no Senate companion.
Mutual assessment of
Yes, sir.
property and casualty insurers. Notice by electronic delivery authorizes
Yes,
a
sir.
mutual assessment.
So House Bill 951 is related to how customers are notified about their insurance assessment, and it just seeks to amend the code so that an assessment can be sent to every member, subject to the assessment, written notice by email. Current law states that assessments right now can only be done either in person or by mail. So this bill just simply says that a mutual assessment company can assess policyholders by email only if members agreed to doing so. Very simple bill.
So they couldn't impose it on somebody that doesn't have a computer.
That's exactly right.
Okay. All right.
Move report.
All right, then a motion and second to report House Bill 951. All those in favor, vote aye.
Ayes 15, no zero.
Thank you, Mr. Chairman, members
Okay.
of the committee.
All right, Delegate Hurst, you're up.
Thank you, Mr. Chairman. I have for you and the committee House Bill 795. 795 is nearly identical to Senate Bill 235, patroned by Senator Barker, relating to association health plans. I would be more than happy to conform my bill to his so that we can keep this moving along.
There you go. All right. All right, it's been moved and seconded that we conform House Bill 795 to Senate Bill 235. All those in favor say aye. Aye. Opposed? All right. The amended bill is before us, and there's a motion, support, and a second to report as amended, House Bill 795. All those in favor vote aye.
Thank you, Mr. Chairman, members of the committee.
You're gone.
Ayes 15,
All right.
no zero.
Next is Delegate Askew. And Delegate Keem, is he here? He's not here. All right, if he's not here, Delegate Heretic, is he here? Okay. All right.
Yeah. All right, you're up, Delegate Askew.
Thank you, Mr. Chair. Today I have before you HB 783, which should be exactly as yours, SB 9.
Okay, workers' comp, was that, that was the fire insurance, the presumption?
Yes, sir, workers'
cancel
compensation.
Presumption bill?
Yes, sir.
Right. Okay, you want to just move to conform it, it's pretty similar anyway.
One word. I left out an article in your version, Article A.
So leave his alone? Okay. All right, on the advice of our counsel, leave his alone, okay? Because there's a one-word difference, and your word is better than mine. All right? All right, the bill's before us.
Move report.
All right, it's been a motion and a second to report, and they've asked for it at finance. Lord only knows why, but anyway, 783, report and refer to finance. All those in favor, vote aye. Opposed? Okay, it was up there.
Thank you, Mr. Chair, members of the
Was there
committee.
money in your budget to cover any potential expenses?
If it's not, I believe it's in you all's, if it's not in ours.
I think it's in ours, but
Yes.
we'll check, okay. All
There's
right.
a strong
Thank you.
smell of smoke up here.
Okay, Delegate Keem's not here. Delegate Harrigan, you're up.
Thank you, Mr. Chairman, Senators. First, briefly, House Bill 440, I would ask to take by for the day.
You what?
Ask to take by for the day.
Bye for the day.
Which one's that?
Your other bill got reported out.
Yes, sir. And I'm here, I have 1244.
Yeah, it's gone.
It's gone too?
Yeah.
Thank you all.
You're done.
Thank you, sir.
All right.
Let's do this again often. Thank you, Senator.
Huh? All right. Keem, you're up.
Mr. Chairman, Senators, I have three, but I understand the first one, House Bill 576 was already taken care of, so I don't need to worry about that one. Okay, thank you,
Wait a
Mr.
second.
Chairman.
576.
Yeah, that was already
That's
resolved.
gone.
That's right.
And you've got
House Bill
1149 and what else?
1334, Mr. Chairman. I'll start with 1149 if that's the chronological order.
Wait a second. Right, okay. 1149. I got it here. Virginia Stock Corporation Act?
Yes, sir. Mr. Chairman, as members know, our corporate law is patterned after the American Bar Association's model law. We've had some upgrades, reforms. Most recent updates were done, I believe, about 2 years ago, 2019 legislation. This version is another set of updates to that, just to make mostly technical amendments. And rather than me try to bore you, if you have any questions, Mr. Alan Goolsby, on behalf of the Bar Association, is here to answer any questions. But this is a Virginia Bar Association Business Law Section bill that comes up routinely for updates.
What are the any major changes, Alan? No.
These literally are all technical. The major changes were made last year.
Okay.
And the clerk's office actually is supportive, and many of them are requested by the clerk's office. Mr. Peck is here.
All right. Any questions of Delegate Keem? Senator Lewis? Move to report. All right, there's a motion and a second to report 1149. All those in favor, vote aye. Opposed? All right. 1149 is reported.
Thank you, Mr. Chairman. House Bill 1334 is similar in that this comes from the State Corporation Commission. This was a part of a stakeholder process that they've engaged in for about 2 years. The Bureau of Insurance has been trying to develop some model legislation that deals with cybersecurity and the breaches and the notification aspect of that. After about 2 years of working with all the stakeholders and through the House process, we've resolved just about every outstanding issue. I understand, Mr. Chairman, that there are at least a couple of members of the public who still have some lingering concerns and such. So rather than me try to explain the bill to you, other than the fact that it's a model law that we're trying to adopt for Virginia, it's a National Association of Insurance Commissioners law that we're trying to adopt for Virginia, I can have our State Corporation Commission, Bureau of Insurance explain if there are any concerns that are raised by the members of the public.
All right, any questions of the patron? All right,
Mr. Chairman,
yeah, Senator Marsden.
a concern was brought to me, Delegate Keane, about the timeframe of that people had to be advised within 3 days, that was a very, very tight time frame, and not, it takes some time to sort out who has been impacted. And it was suggested to me 30 days, but I, in some discussions, talked about doing it as a 15-day period of time. And would you consider that a friendly amendment?
Mr. Chairman, I'd answer Senator Marsden by telling you that if I drafted this bill on my own from the get-go, I would consider that to be a friendly amendment, but this was a product that came out of 2 years of stakeholder process, so I would defer that answer to our State Corporation Commission. If they feel comfortable with that date, because right now the bill that we have in front of you is a 3-day notification for the breach, and under some HIPAA laws and other laws, the timing might be a little bit longer. So I would actually, if it's okay with the committee, I'd prefer to hear from the State Corporation Commission to see where their comfort might be. Again, if it's up to me, I would draft it a different way, but Mr. Chairman, would that be okay?
Behind you.
Would that be okay to have? Mrs. Johnson, thank you.
Good afternoon. Excuse me, Mr. Chairman and members of the committee. Katie Johnson with the Bureau of Insurance. To Senator Marsden's question, the 3-day notice requirement is once you've determined that you actually have a cyber event. So that may take several months. So it's only, you start, you get notice that something may be going on, so then the company investigates and finds out that they actually had something that falls under this law. Then they have 3 days to notify the commissioner. So it's not 3 days from the first inkling.
Gotcha.
It is 3 days from when and we actually added language to the bill that says when it's actually determined that a cyber event occurred. Then they have 3 more days to notify the commissioner.
Thank you.
That was a question I couldn't answer.
Okay, any other questions of Delegate Keane on House Bill 1334? All right, Bills, anyone you want to testify for or against?
For Mr. Chairman, Bob Bradshaw with the Independent Insurance Agents of Virginia. We in our National Association worked on the NAIC model for it seemed to be about 2 years, and then we appreciated the opportunity to work with the Bureau of Insurance for another 2 years, providing input on this bill, and look forward to working with the Bureau on the regulatory process. So thank you. We're in support of the bill.
All right.
If you'll take opposed, Mr. Chairman, I think I probably fall into that category. Patrick Cushing on behalf of the American Council of Life Insurers, and we are a major stakeholder in this. And for the past 2 years, my client has been working with the Bureau and trying to adopt.
Mr. Chairman, is he for or against?
I'm in the opposed category.
Oh, thank you.
Yeah. I didn't think there were any more in favor. And so we've been working with the Bureau to try to develop amendments to the model law that would be consistent with what's been adopted in 6 of the 8 states that have taken the NAIC model and adopted them. In 6 of those 8 states, there's a provision that I'll call the materiality trigger that have been adopted. It wasn't a component of the model law, but now we have 6 of 8 states that have adopted that. And essentially what it does is it says in the definition of cybersecurity breach that there has to be some reasonable likelihood of harm before we notify the commissioner and before we notify the consumer. On the House, it's an amendment that's very important to the life insurance industry for this bill. We requested that amendment on the House side, and I would say we got half of that amendment. We have that materiality trigger for notice to consumers so that there has to be some reasonable likelihood of harm before we notify consumers. We don't want to over-notify in this instance. That same materiality trigger was not added in the notice to the commissioner section of the bill. It is something that we have in our database breach law for all other companies that operate under our database breach law in Title 18.2. We have this materiality trigger. There's budget language that governs tax preparers and how they notify for breaches. And that notification provision has this materiality trigger saying there has to be some reasonable likelihood of harm before we send notice to the consumer. Without having that for the notice to the commissioner as well, We think that's a major point of contention for us and deconforms from what has been adopted in the majority of the states so far. We have to oppose for that reason. There are a number of other amendments that were not added to this bill through the stakeholder process that deviate from what 6 of the 8 states have adopted. And so some of those are technical, some of those are substantive, but I wanted to highlight really our key differentiator and why we have to stand in the opposed column, even though we do want to see states adopt statutory cybersecurity event breach notice legislation.
Mr. Chairman? Question for Patrick. So the company itself would make the determination as to whether the evidence for the breach was significant enough to report. Is there any outside review of that or whatever? Is it just because we've had so many situations where companies have sat on things knowing it's bad and not releasing them, not releasing that information, and then all heck breaks loose. What guarantee would we have that the company would report accurately as to what the situation was or wasn't?
Yeah, Mr. Chairman, Senator Morrison, good question. So when I go back and look at Title 18.2, there's criminal penalty provisions that if you don't provide the notification, there's criminal penalties. When the Bureau adopted this model, one of the things that we wanted and they wanted and we think is a great provision is there is no criminal penalty, but your ability to operate in Virginia as a company is going to be on the line. So that's the motivating factor when you look at companies that may have a breach that would require notification. If they see, under a materiality trigger that I described, if they see a reasonable likelihood of harm, they're going to want to notify, because if they don't notify and the commission reviews and finds out about it, their license to operate in Virginia could be revoked. And we think that's a pretty significant incentive to provide the appropriate notification.
No, nobody's smoking.
Mr. If there are further questions, we have another staff from the Bureau. If not, I'd be happy to answer any questions as well.
All right, bills before us.
Move the report.
All right, there's been a motion and second to report House Bill 1334. All those in favor vote aye. Opposed, nay. Bills reported.
That's 15-0.
Thank you, Mr. Chair.
Okay.
Appreciate the members. Thanks.
Delegate Tyler. The bill is similar.
House Bill 169.
Yeah, Delegate Tyler, your bill is on workers' comp, occupational disease presumption for correctional officers, is similar
Yes.
to Senate Bill 345, which passes committee 14-1.
Correct.
And the Senate 40-0. My recommendation is going to be to the committee that we align your bill directly with Senate Bill 345. It has to be reported and go to finance. Now, when yours was up there, what did they tell you?
Mr. Chairman, my bill is in the budget, and
It's in the budget.
It is.
So the money's in there.
Mr.
Yes.
Chairman, I have worked with Delegate Tyler for many years on this bill since I've been in General Assembly, and I know she worked on it long before I was here. The only difference, I think, is adding the DMV officers. There's only 65, so it's a very small difference. The bulk of the officers affected are the correctional officers. So with that, Mr. Chairman, I so move to conform.
Okay, there's been a motion, I need a second, to conform House Bill 169 with Senate Bill 345. The motion, first of all those in favor of adopting that amendment, say aye.
Aye.
All right. House Bill 169 as amended is before us. The motion would be to report and refer. The money's in the budget. I don't see where it really needs to go there.
Mr. Chairman, I also say it was only $20,000 a year. It was a
Right.
really small amount.
All right.
So, and I also should say, again, Delegate Tyler's worked on this for many years, advocate for the correctional officers, and commend her for her
All right, we'll
leadership.
go directly to the floor. The motion would be to report as amended, House Bill 169. There's been a motion, second, to report 169. All those in favor, vote aye.
Thank you, committee. It was worth the wait. Thank you.
Ayes 15-0.
I don't know about that, but anyway. Next on the list here is Delegate Myers. Not here. All right, Delegate Hope, you're up.
Thank you, Mr. Chairman. This is House Bill 727. You passed a very similar bill in Senate Bill 720, 15-0, and I would be fine if you wanted to conform that bill.
Okay, that also was going to finance, that was Senator McClellan's bill,
Yes, sir.
720. You want to give a brief description of what the bill does, and then we'll make the motion?
It provides training for 911 operators.
Okay. All right, the motion is, do I need a second? To conform 727 with Senate Bill 720, which is Senator McClellan's. That passed 15-0 here and 40-0 on the floor. All those in favor of conforming 727 House Bill with Senate Bill 720, say aye. Aye. All right, bills before us. All right, motion to report and refer to finance. All right, all those in favor, vote aye.
Ayes 15-0.
Thank you, Mr. Chairman, members of the committee.
Okay. We did Ed and Hill.
Yes.
Leftwich. All right, here's some internal. Delegate Simon's bill, HB 10, has to go immediately to finance and appropriations. All right. Is there a second? All right, all those in favor of referring it directly to re-referred, it's not reported, it's re-referred to finance for House Bill 10, vote aye. All right, and one last piece of internal housekeeping, HB 1380, which is Delegate Leftwich's bill, has to be re-referred to the Judiciary Committee. I hear a motion? All right, that's 1380. A second? All right, it's been moved and seconded that House Bill 1380 be re-referred to Judiciary. All those in favor, vote aye. That takes care of that. All right. Anybody left from the House? Well, if there's, they're not here, they've been notified. The committee will rise.
Mr. Chair,
What?
did Delegate Mayares was here? Oh, he finally gave up.
Yeah, well,
He was
we
here for a long time.
don't know how long he's gonna be in subcommittee.
Yeah. He's on his
He's
way.
what? He is or he may be. Yeah. All right, well, we'll carry it over till next week. It'll go by for the day, and we'll hear it next Monday. Okay? All right, committee will rise.